Hearing board to order. Do we have two appeals tonight? Because I don't see the other part for the second, for 2823 here.
I don't see 2823 either.
Well, then we'll start with the other one then. John, have you had a chance to read this?
No, I don't think I have.
Okay. This is a letter we received, I guess, January 20th from James Schneller. It's about a 3-page letter, so I'm not going to read it into the record, but since you're here, would you like to give us a very brief synopsis of what you're asking for? Come up to the... I'm requesting. It's either that or I have to read this into... And brief. We will, I guess we should swear you in just in case, and please give us your name and address.
Sir, you promise to tell the truth, the whole truth, nothing but the truth.
I do.
State your name for the record, please.
James Schneller.
Can you briefly summarize this letter in like a paragraph?
Yes. I'm asking in the letter the Board of Commissioners to investigate, form a committee, or otherwise grant relief regarding the hearing held last month in regard to 103 North Wayne. I tried to avoid bringing up A, anything of record in that appeal, or B, any legal arguments. I raised items like
Mr. Schneller, let me just stop you here. You're basically addressing this to the Board of Commissioners then, not to us?
Yes.
And you gave us this for informational purposes, is that correct?
Yes, I simply copied it
Okay.
in a letter.
Yeah, all right. That's all we need to know. Thank you very much. So then we could just read this for our information, and the commissioners will handle it in the appropriate manner. All right. Let's see. Was it 2A? Okay. All right, 2823, which is the Len Wayne Properties, is not here at this time, so we will start with 2825, the applicant Virginia B. Campbell, located at 516 West Wayne Avenue, Wayne, Pennsylvania, seeks to replace an existing enclosed porch at the rear of the residence with a room that can be used as a bedroom at some time in the future, and that will contain bathroom facilities. Applicant requests a variance from the requirements of said section 28020D1 so that the proposed new room can be approximately the same width as the residence and be approximately the same distance from the eastern property line as the existing residence. Yeah. Yes, sir.
Good evening, zoners. Harry Spees here from Davis, Bennett, Spees, and Livingood in Wayne, representing the applicant, Virginia Campbell. I'd like to make a short introductory statement, and then we would have two witnesses, Mrs. Campbell and the contractor, Mark Campbell, who is also her son. Could I introduce the exhibits first?
Yes, please.
I'd like to...
And are they numbered also?
I have numbered them.
Okay.
And A1, applicants 1, would be the application to the zoning
All right.
board.
Let me number what's in our file here then. This is A1.
Yes. And attached to that are photographs of the subject property and the adjacent properties together, and also attached are copies of the two recent deeds into
Is that
Mrs.
all
Campbell.
A1? Or
That's all A1, yes.
Now, the A1 then would include this plan here labeled SK1?
It does. I'm going to introduce as the next exhibit a larger sketch plan.
That's fine.
So A1 is the application with the photographs and deed, copy of the deed. A2 would be a larger site plan designated SK1, which is really the nuts and bolts of our case. It shows the side yard invasion, which is the reason we're here. That is A2, excuse me. A3 are the site plans, including about 4 sheets prepared by the architect of record, Ecovision LLC.
And that's labeled CS.
Yes, it is. The top sheet is labeled CS. The second sheet is labeled A.1. The third sheet is labeled A.2. And the fourth and final sheet is labeled A.3. Applicant's Exhibit 4 is a list of the immediate neighbors to the property, indicating that they concur with the application. They have no objection, and that is signed by 3 of the immediate neighbors.
Do we have that?
You do
I
not
don't see
have that?
that.
I'd like to hand that up.
So this would be A4?
Correct. And fifth and finally, A5 is an extract of the Radnor Township zoning ordinance of 1928, the front page, and then the section, the applicable section. This property was built in 1947, and as evidence of that, we only have anecdotal history of that, but the deed, which is in A1, indicates that there was a plan and survey of Yerkes Engineering and the developer, Emschwauer, dated August 7, 1946. And it's our position that by 1947, a year later, this property was built. And at that time, there was a different, this was in an A residence zoning district in Radnor Township under the 1928 zoning code. And I'd like to just mention, and I'll hand this up because I don't believe you have this either, in the section 305 of the zone, only required an aggregate width for side yards of 30 feet rather than 45 today. Neither side yard in those days shall be less than 10 feet wide. That is why this property is non-conforming. It already invades the westerly side yard by about 3 feet or 2 feet 2 inches, but it did not invade the side yard requirement when it was built. So that is A5.
Thank you. John, do you need to see this?
Pardon me?
Do you need to see this?
Yeah, I'd like to quickly, if I could.
May we swear in your witnesses, please?
Yes.
If you will both raise your right hand. You do solemnly swear or affirm that the testimony you have asked will be the truth, the whole truth, nothing but the truth. And if I can get your names one at a time, please.
Virginia B. Campbell, C-A-M-P-B-E-L-L.
Thank you.
Mark Campbell.
And Mark is spelled.
Mrs. Campbell, your address is,
516 West Wayne Avenue, Wayne,
and how long have you resided there?
since September 1971.
What is the age of your home?
Our understanding has always been it's about 62 years, about 1947. That's our understanding we bought.
And your lot is 80 feet in width by 347 feet in depth?
Yes.
And could you describe the home and its location on the lot? Just tell us about the home.
It's a two-story colonial, basically more towards the street than the back. It's a huge backyard.
Yeah, I know.
3 bedrooms.
Mr. Spees, can I?
Yes.
May I just ask a question? According to your survey, taken from the garage on the, I guess that's the right-hand side, I don't see where the north arrow is on this. But if you hold the plan thus with SK1 at the bottom, the yard from the garage to the property line is 12 feet 6 inches, and the yard to the left is a 20-foot yard. Is that correct?
The house presently
I mean,
goes
I'm
into
using the
that-
worst-case scenario. Based
Yeah.
on the worst-case scenario, it appears that on the left, you've got a 20-foot yard, and with the garage, you've got a 12-foot yard. And based on the old ordinance, all you needed at the time was an aggregate of 30 feet, which you exceed by 2.6 feet, and
Correct.
individual yards of 10 feet, which in each case, this property
It complied.
complies with.
Yeah.
I just wanted to point out that assuming this was the ordinance in effect when the building was built, even counting the garage, with respect to yards, it fully complied with the ordinance. Yeah, this is unless you're violating some other requirement that you don't presently violate, and I don't see that here. Your impervious and your building coverage are fine.
Correct.
Your lot area is fine. It seems to me that this is a straight 101B1 special exception.
Would you prefer that I dispense with the testimony?
At your discretion, but I personally don't think I need any.
No. Yeah.
We are not going to further go into the side yard with the enclosed room that will be built in place of the enclosed porch that presently exists.
And you're not asking for relief for anything other than the side yard? You're not asking for any impervious, rear yard,
We
anything
comply in
else?
all other respects with the current code.
Okay.
Okay. Do any board members have any additional questions?
I have no questions.
Would you like to move to make your,
I'd like to move the exhibits into evidence.
and we'll close the record on this. Charlie, would you like?
We have to answer the neighbor.
Oh, anybody in the audience have anything to say? Yes, come up, please, and be sworn in. Oh, yes, I'm sorry, we need to reopen the record here.
Oh, no,
Okay.
it's okay. I don't need.
Go ahead.
Ma'am, if you'll raise your right hand and swear, you do solemnly swear or affirm the testimony you're about to give will be the truth and the truth.
Yes.
And state your full name, please.
I'm Jane Golis. I live at 512 West Wayne Avenue. I'm Ginny's next-door neighbor on the side to which she's going to move her porch in line with the rest of her house. I encourage you to approve this. It does not impact my house, and I think it'll make her home more comfortable. I sent you a letter to that effect. I don't know if you got that.
All right, very good,
All right.
thank you.
Am I?
Spell your name for me.
Oh, Golas. And there's lots of bushes and trees anyway between our properties.
Thank you. Mr. Spees, did you want to say anything else?
No, that would be
We were sort
our
of cutting you
case,
off there, but,
That's okay. That's okay.
right.
My wife will wonder why I get home so early tonight.
all right. Any other comments from the board? If not, then we will close the record. Charlie?
Yeah, I would grant them, and it's not section 280-20D1. It's really a 280-101B1 as a non-conforming, so I would grant them that
Jim?
section.
I agree.
Yes. So it passes then. Thank you. Before we adjourn, I just wanted to note, I did, when I rooted through this other file, find a letter requesting a continuance for 2823, the Len Wayne properties. Dear Matt, kindly continue the zoning hearing on the above schedule for January 19th to the next scheduled zoning hearing in March 2010. The reason for the continuance is that the applicant is considering revising the plans after meeting with the neighbors. The applicant agrees to extend the time when the board can hear this matter for an additional 30 days. Thank you for your time and consideration. Very truly yours, Nicholas Cornelia. And, yes, he does say March. I believe it would be February,
Unless he wants to come March.
Well, I
but he's
mean,
asking for 30 days.
yeah, I mean, he's extended the thing for 30 days, and I don't know what the continuance is. What my recommendation would be is to continue it to February, And someone should ask Mr. Cornelia whether he meant February or March, and I would...
Could
if
you
he-
follow up
I will
with that?
follow up, and frankly, if he confirms that it's March, I would urge the board to accept that. In fact, I see no reason, if the board is willing to do March or February, why we can't approve a March extension if he sends us a letter that makes it clear that it is March and that the continuance of days goes to the March hearing.
Okay.
All right. So should we just say March, and if he
No,
shows-
say February, but it's February unless he confirms that it's
February,
March.
okay.
Would be what my recommendation.
All right.
And
Is
if I could
everybody
have
all
that-
right with that?
Yes.
All right.
Could I take that letter with
Sure.
me? I'll call him tomorrow.
Thank you. Now, before we adjourn, I've got an assignment for everybody. We've run into various things along the way where we had to enforce certain rules that we didn't particularly like, we thought did not make sense. And I think we might want to address some of them and write up our comments. If you could email them to me, then we'll talk to John about it, or maybe other times when we have a short meeting, we can discuss it among ourselves and perhaps make recommendations to the commissioners about, we think these items are problems in our current zoning code, and we'd like to see them addressed. Does anybody have a problem if we approach this?
We can certainly make recommendations either as a board or individually. If they are issues with the application requirements, then we have the authority to change those ourselves.
The only issue I have with the application requirements are that the applicant sends out the notices as opposed to the township.
Okay.
I really think that's a big hole. And I think, and I know some specific cases that I won't name, but they should have been sent out by the township. So I think we should change that, and I know we had to change it because the township had something different.
Yeah, the township has a rule that the applicant sends it, and there is unfortunately some play if there are two conflicting sets of requirements, because the township can impose requirements per the ordinance, which it has done, then the applicant has to comply with the more restrictive, least favorable to the applicant. That's the problem there. And our requirements originally suggested, stated that the township does the mailings, and now the township ordinance states that the applicant does it. And I gather that's something that, the board might like to see changed so that the township did the mailings.
How does the board feel about that? Is that one you think we should pursue?
Yeah, I think if the township's worried about the cost, then you just add it into
Add it in,
the application
right.
fee, and it covers the cost of doing it, and whatever it costs. I think the township should do it. That way you know it gets done, and the
You know
right
who it's
people are
going to.
getting it. Someone's not gonna come here and say, I didn't get it, and the applicant's gonna say, well, I thought I mailed it to everybody, and then we've got a problem. I think. We talked about that. We had a couple, I forget which one it was, but it happened a couple times where people didn't get the information, because one thing said one thing and the other
Right.
application said something different.
That's why I think the township should do it. Does anybody else have any feelings with that?
Is it because save money for the township?
Just charge them.
What is that?
No, we charge the applicant. If we have to if the applicant needs to send out 100 letters, you charge the applicant for 100 letters.
Why the township made the decision in the other way?
Is there a staffing issue in terms of it takes time to get the letters out as well as the postage?
Well, lots of times, for example, a receptionist could put the postage and stuff the letters on there while she's on the phone or something like that. Maybe there is, but I think, is there a staffing problem?
Yes.
Yeah, I know there is now. Is it impossible? Uh,
I am not the zoning officer, but I'm going to say we are very, very short.
I know you are now, yeah. But this is not something that would happen now. It's something that would have to change. And then I'm hoping down the road there'll be less of a staffing issue.
The requirement now is that it has to be sent out by a certain time to neighbors within a certain radius.
But by the applicant.
By the applicant, but there's no burden of proof on the person who's making the request to show that they did it at all, let alone in a timely manner. And I know when I did it, I asked, do I need to have a receipt to show? No, just tell us you did it. So it seems to me that it would be much cleaner to have the township do it. I understand the staffing difficulties, but
I think in terms of as we all know, with the Glengarry case and its progeny, procedure becomes more important because the penalty for a breakdown in procedure or a failure to conform with procedure, if it's material, is that the decision can be challenged indefinitely as void from its inception. So it's important that the procedural stuff be done. And I guess the township being understaffed now, maybe it's not the time to put it in now, but at least at a future time, it may be more reliable to make sure that that is done, to have the township be involved with that.
Well, and as you say, John, under Glengarry, the risk is always on the applicant.
Yeah, that's true.
So there may, I haven't really given it a ton of thought, but what about, could there be some theoretical liability based on a duty undertaken and done negligently? I don't want to over-lawyer it, but.
I wouldn't see a liability of the board. First of all,
No,
I
the
think
board, clearly
or
not.
the township, if the directions are
Probably.
clear, as to what they have to do,
Yeah.
and they don't do it, I am unaware of a liability,
No,
a palpable
I
liability.
think maybe the issue is, what if the township takes on the responsibility and the township fails to send the notice properly? No one finds out about that until the fat's in the fire. Whereas if the applicant's doing it, it's the applicant's ox that's being gored. He has to make sure he does it properly, or he will suffer the possible loss of his relief. Give it to the township, and if the applicant relies on the township,
Then there may be an
mistakes happen,
estoppel.
something slips
Well,
between
then-
the cracks.
Yeah, I understand both sides. Then maybe, we could ask for proof from the applicant that X number of letters were mailed on such and such a date.
You could get an affidavit, or even better, have them start their sworn testimony. The first question is, I have sent the following notices on or before the following date, and introduce the notice to the board, and that way you have it on the record that
Right.
they've made their representation.
My only, excuse me, Mr. Schneller, we haven't opened for public comment. Again, the issue, the burden and the risk is lies solely with the applicant, so.
But I'm thinking of one in particular, which I really don't want to name
I
publicly,
understand.
that I understand nothing was mailed out.
I
It
see.
passed
Okay,
because there was nobody here to object to it.
I see. I understand.
And
So in certain circumstances, it may, just in terms of the process, be best for the board to ensure that there's full public.
that something went, right.
I understand.
But if the applicant had made a sworn representation at the start of the hearing that it was done to the following people, here's the notice.
Well, the problem was this particular applicant swore to several things that haven't proven to be true.
Well, then he won't get the benefit of the relief.
Or the relief is, if the
The
applicant,
relief was given,
Well,
that's
could
the
I
problem.
mean, he wouldn't be
Yeah.
entitled to
Procured by
relief.
fraud. I mean,
The
it could
relief could be
theoretically be
withdrawn.
brought.
Yeah.
well, the point that being then, if we grant an approval and the applicant says that they have complied with the posting and the mailing, and they have not done so, and that's a procedural gaffe that could be attacked beyond the 30-day appeal period, and they take the risk of that.
Right. So you feel that if our
And
first
making a
question.
false sworn statement to authorities also,
Yeah.
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 which is
Even if it's
itself-
not, even if it's, if it was not a sworn statement, if they have the duty, I think the duty has to be clear as to where they're supposed to send the letters, and they have to be given but I think the application requirements have requirements for that as of the ordinance, and just make sure they're clear.
But John, here's my problem with all this. We wouldn't have this problem. We wouldn't have to worry about them lying. We wouldn't have to worry about it going out. The township does it. The applicant pays for it. Whatever it costs, the applicant pays. And if we have to send it out for a separate place to do it, then the applicant pays. Then we know it's out. We don't have to worry about sworn depositions that he did or didn't, or she did or didn't send it out. And you just move the cost over.
Who determines the list of who must receive notices
it's,
at what addresses?
It's within a radius of the applicant.
But who actually physically decides who's within that
I think the
radius?
township
township
gives them
does. Gives them a list.
labels.
So we give them a list. and
Yep.
they just-
Yeah.
So, I mean, I don't, whatever it costs, they pay. Then we don't have the issue of, hey, I didn't get a letter. You know, now we know, in fact, it did go out. You know, sometimes you mail the letter, and it doesn't get to that person. And that person may be the individual who has the greatest grievance against this getting done. You know, I didn't get a letter, but well, I sent it, you know? If the township does it, we get rid of all that ambiguity, I think. You know, just let them pay, whatever it
Well,
costs,
just the
let them pay.
township gets blamed for the person who says he didn't get the letter, whether he got it or
Right.
not.
Charlie, Charlie, I'm sorry, in all fairness, what's the difference whether you stick it in the post office or we put it in the post
Well,
office?
here, the difference is, if you put it in the post office, we know it went, right? I mean, there's no,
Why is your mail different than our mail?
yeah, but what I'm saying is if I'm an applicant and I mail it, okay? And, I say, I did in fact mail it, and for some crazy reason, some people don't get it. And now we're saying, are you lying to us? Did you in fact mail it? See, we've taken that away.
The same thing.
But I think the difference,
But if you say you mailed it, we know it's mailed.
the difference is motivation. You have no motivation not to mail it. It's your job to mail it, and unless a mistake is made, you mail it. Whereas an applicant may have a motivation not to send Mrs. So-and-so that notice because he knows she's going to object. So he accidentally forgets to send that one.
But don't they have to, again, you have to get the proof of mailing.
But
Don't
The
just-
last time I
have we
was
been
bef-
getting that?
I mean, the last time I was before this board, before I came on as solicitor, we had to bring in a proof of mailing.
Okay, yeah, all right, suppose you have to mail 50 letters, okay? So I'm gonna mail 50, I go to the post office and I mail 50 letters. I mail 50 letters to the same person. I come in with a thing and say, I mailed 50 letters, here's my thing. Here's my post office here's my $200 that I sent it.
How about the list of addresses, They should
Yeah,
submit.
unless, I don't know, a post office is gonna check every single name who you mailed it to.
No, no,
And the
no.
only thing we're gonna
No.
ask for is a receipt that he in fact mailed them.
All we're really gonna ask is for a certificate of service, a sworn statement that I sent the stuff out.
Right.
That's all, we can't
Yep.
require proof of delivery, we can
No.
only require proof of service.
Right.
And I think.
Service is complete upon mailing.
And I think that we take that craziness away if the township does it. I think
Well-
I think we cut away, and let them pay, right? I mean,
Yeah.
whoever, my thing would be, we hire somebody to do it, an outside mailing company, right? And we give them all the information, and we charge the applicant. That way the township doesn't have to worry about it, you're not gonna be understaffed or overstaffed, and it's taken care of. I don't know what the problem
I
is.
guess the one thing, Charlie, I would respond to that, there may be some reticence, not all applicants, for some applicants, a higher mailing charge is going to be more problematic than for others. We've had that with the application requirements, which used to be guidelines, and oddly enough, sometimes it's the, financially stronger applicants who complain the most about the application requirements imposing a cost, and the other people just simply do it. But the requirements impose a cost, and I know there was some concern expressed by a couple of commissioners when we put the guidelines into place about imposing excess costs on people who may not be able to afford them. If it's beyond what the normal mailing is in terms of a company or paying somebody, paying a portion of a salary of a township employee or something to offset the time that a township employee is putting into the thing. I'm not offering any kind of a position on that, but I remember that being a concern when we did the requirements, and one that I think properly we agreed. We simply needed to have complete applications in advance of the hearing, and our function has been far better since the application guidelines became requirements. I think our function has been
John,
much
I
better.
have, and anyone I've done, and I haven't done any recently, but any application I've ever made for a zoning variance, I've never mailed a letter. The township has always mailed a letter for me. I've never done it. Has anyone else ever applied for a zoning in another township? Right, in another township. I've never done one. Have you ever done one?
I've probably done 1,000 of them, but I wouldn't remember because it would have been handled by staff.
Right, and I doubt if your office did the mailings. I'm sure the townships do it, because, I mean, like I said, this is the only time I've ever heard in that one case we had.
Well, we're fortunate. We're not a legislative body. I think all we have to do is advise the commissioners that we're concerned about the issue, and the commissioners will examine it and do what they want with it. We have no power to change this. If we find that this is a potential issue, I think we should advise them of that, and they'll take it under advisement and do what they want with it, since they're the only ones that have the power to change it.
Since this isn't going to change overnight, and hopefully the situation at the township will improve, why don't we put it on our wish list?
I do think it'd be a good idea to suggest that at a minimum, that there
Proof.
be a question under sworn testimony
Right.
about it.
And also, does it cost anything to ask the post office to certify that you mailed 50 letters or whatever? I don't know, I've never done it.
Just you get a receipt for the mail.
Just a receipt for the
Yeah.
mail.
It
It's
costs something, but it's small.
like $1 or $2.
I mean, probably less than, I don't know.
Okay.
lately,
Just ask
but-
for a receipt for the mail. If it's 41 cents, and there's 50 of them, it's 41 cents times 50, and it says it's mailed from such and such post office, and you got a receipt.
It could be the Christmas cards, but.
Well, but yeah, I mean, that's
That's the point.
It's not just a receipt for the postage, it's a receipt for that mailing.
Sworn testimony, that's.
Right,
Okay.
it's gonna work.
All right, well, let's put it on our wish list. You probably don't want to take the time now, but just think about some things we've run into that we think need to be changed, like definitions in the code.
Requirements is one of the issues.
Height?
Height requirements in the institutional zone. I think we've had some trouble with that.
Taller or
We wrote a letter.
shorter?
It
I
should
thought they
go up.
changed that. We wrote a letter
It's
about
too
that a couple,
short.
3 years
Yeah.
ago, right. The new standards are different than they were before, but we wrote a letter I wrote the letter, in fact, and sent it to the commissioners about that.
Yes, you're-
Yep, and that was a couple, 3 years ago.
Right.
And I
Well,
thought
that was
they-
after one of the Villanova
Right.
events.
Right.
Yeah, yeah.
And I thought they changed it. I thought they did change the height inside
I don't think we
classrooms.
had
it
much of
was. It
any
was classrooms.
changes in our
We've
code.
had building height issues.
That was a building height, because the
Yeah.
floors were greater, the
Yeah,
height had
because
to
of
go
the
up.
HVAC
Right.
requirements and
Right.
Right.
internet and that type of thing. And that was institutional, and actually, that would probably be institutional and office, both.
Yep. Probably everything now.
Plus, if you're building green buildings now, they tend to make them higher and have more
The green
glass.
roof is not in our code, yeah.
But I mean,
Nor is bed and breakfast.
but trying to
Yes.
make a green building does usually involve
That was next on my
And
list.
I think we should
Greater window
decrease
height.
the impervious area.
I am so
Especially around
surprised to hear
Charlie,
you say that.
right?
Well, should we have something in the code about pervious pavers? I mean, that's really an engineering issue.
Yeah.
I'm not sure we should touch that.
No. There's nothing in there, he said, when he came, Dan Malloy came.
Yeah, there's nothing there,
There's
but
nothing there.
But he didn't want it in, I thought, at one
No,
time.
at one time we gave credit, and
Right.
then the engineering department, I think, said,
Don't do
No,
that.
we're
because
not-
they'd pave over
we
it.
are not happy with it, they
Right.
get clogged,
Need
et cetera, et cetera.
Mhm.
I agree with that.
Does that sound right, Ray?
Yeah,
On the pervious paver
I
thing?
think that's what it was, yes.
Yeah.
okay, bed and breakfast, readdressing that issue.
Yeah.
We don't have billboard issues, do we here?
There is another billboard ordinance that was written that hasn't, there was one put through during the summer, and then a redo of it that we did in August, that committee I was involved with, and that hasn't hit the commissioners yet, and it really needs to, because
Do we have any place you can put a billboard in our township?
we,
Off-premise
we
signage.
have, yeah, well, right now they allow them, as per the first one that was put through this summer. But I think the second one that was written is better, and that hasn't been introduced yet. That was finished in August.
And with all due respect, I can understand why we would concern ourselves with the notice issues for hearings, because it goes to the efficacy of what we're going to be doing. But do we really have the role of advising the commissioners on the substantive issues of the ordinance? Isn't that really the
Probably
province of the
not.
planning commission? And the-
No. Well, here's the thing. I've been on this for like 15 years now, and these problems have come up frequently. Yeah, and we've had to approve things that we didn't necessarily want to because we didn't think it was good, or we had to turn down things that we thought were good because the code would not allow it. And, you know, I know it would be nice if some group got together and did this, but since it's not necessarily happening, I thought maybe we could put our 2 cents in and give a list of things that we feel need some improving. Whether they act on them or not, I
I
don't know.
mean, not as a zoning hearing board, but as concerned
No,
citizens.
yeah.
I don't think there's anybody in the township that has more expertise about things in this nature than this board is. We hear all of them.
Yeah.
You know, we hear all kinds of goods and bads.
No, I think, you know, again, we can certainly comment in our individual capacity, but I think that we ought to be focusing on things that are causing a problem with the function of this board or the, you know, interpretation of the ordinance. As, for example, if it is perceived that the ordinance is exclusionary or doesn't provide enough opportunity to withstand a legal attack on some particular use, that's different from we ought to locate off-premises signs in a different district. So I think, I mean, the notice is, to me, not a planning issue. It's an issue of, are these hearings being properly advertised? And frankly, I acknowledge that it's the applicant's ox that is gored if there's a procedural breakdown. But personally, I don't like to see a procedural breakdown because I don't like our decisions to be attackable beyond the 30-day appeal period because there's been a bust on the procedure, even if it's the applicant who takes the risk on that.
Well, if you don't feel working as a board, if you don't feel comfortable working as a board on suggestions, if you have some suggestions, you can email to me and I'll follow up with people as an individual.
I'm comfortable.
What's the feeling of the board?
Some definitions of traffic.
Yeah, I have definitions, yeah. I think we need to update definitions along with, you know, what's available now in the world of building,
Especially with the internet.
the green stuff.
Yeah.
I agree.
And if we can help them to do that,
Right. I don't
We
think
can
we're.
give it to 'em.
I mean, we clearly don't have any legislative power
Right.
whatsoever, but certainly we can advise, as anybody could.
these are problems we've run into, you might want to address.
Right.
Okay. All right. Then think about it, send me emails, and we'll forward them on. We don't need to do it immediately, but, you know, over the next few months.
How will you present it? As Noah was suggesting, we do not have the power to change.
As concerned citizens, we take off our zoning hat.
Or to some degree, particularly if it impacts the function of this board. I don't have a problem with the board taking a position on those issues. Board is concerned that its decisions not be attacked for procedural breakdowns. And we feel that if the board were to come to that conclusion, that the township doing the mailings will reduce that risk, that seems to me to be a perfectly fair thing to do.
Okay. And green roofs. You know, can that be counted in with impervious? We really now cannot do that, or count in with pervious, I should say. But we let one go through.
Yes, we did.
All right, all right.
You know, Kathy, one of the reasons, our old twin houses and all, you know, too long and all, we had to revise those setback requirements, side setback especially.
I didn't necessarily want to get into side yard and rear yard setbacks. I was thinking more philosophically or definition-wise.
Definition-wise, I can see if the board is having a problem figuring out exactly where the commissioners
Yeah.
decided to draw the line on a particular issue, I think that's appropriate. But I think if you start saying, well, I think the height limitation ought to be changed, or the side yards changed, I think we're stepping over a line there, because it's not our discretion that's the issue there. It's just our ability to perform our function. We need to know where the lines are drawn in defining this, prohibiting this, permitting that.
Right.
If we need help on that, they ought to clarify it for us by amending the legislation.
Well, I think if it depends on how we're approaching it. If we're approaching it as zoning board members, I would agree with that. But if we're approaching it as a group of citizens who happen to be on the zoning board and may have some special insight And I think we have a reasonable obligation, frankly, to make suggestions that they consider them. They do what they want with them, obviously.
It does come from the viewpoint, for example, the height limitation in institutional districts has come from the situation where we've granted variance relief, which under the circumstances, I think, was fully supportable under Pennsylvania law. And frankly, if you have an ordinance that doesn't adequately address the customary parameters of the use as they exist now in 2010, as opposed to what they were in 1960 or something, then your ordinance, if you have to be granting variance relief from an ordinance to allow the reasonable use as it's evolved over the past number of years, X number of years, then maybe the ordinance ought to be changed. Maybe the ordinance is obsolete on that point, or obsolescent. I wouldn't want to say obsolete, you know, but that kind of a thing is not so much in my view as we like a different height, but this ordinance as it is written is conducive to more legitimate variance relief, and maybe the shoe ought to be recrafted to better fit the foot we're trying to put it on.
Okay. All right. All right. Any other comments from the board on special projects? Okay, then the meeting's adjourned. Thank you.
Thank you.
Thank you.